to deliberate on the topic. Sir, over to you.
Yeah, thank you. So, good afternoon. Welcome back to this workshop. I'm audible?
Yes, sir.
Okay.
Yes.
Okay. So I am aware of the second half session, difficulties of the second half session because of our post-lunch lethargy. There is no wrong in it. I mean, since we are the human beings, I'll try to make my presentation interesting for your attention, but only suggestion that you please interact. Whenever the question arises in your mind, kindly ask me to make the session live. I really appreciate the level of interaction we had in the first session. So kindly maintain it. So here we go. I am now sharing my presentation. Just a minute. So you can see my presentation, I believe. Is it visible, my presentation?
No, sir. No, sir.
No. Just a minute. Is it visible now? Hello, is it visible?
Yes, sir.
Yes, thank you so much. Thank you. So now we'll discuss about the prepackaged insolvency. So let's go. Let me make it the right presentation now. So as usual, some disclaimer from my side. Okay. Friends, I propose for the coverage of this session like this. We'll discuss about the background and framework of PPIRP, that is prepackaged insolvency resolution process. The key highlights of this process. May I request all the participants to kindly mute yourself.
Diversion जरूरी है.
Hello. May I request all the participants kindly mute yourself.
ये वाला नहीं देखते हैं बिल्कुल. वहाँ इन्हें सिर्फ एक ही कमरा याद आता है.
May I request kindly mute yourself.
या तो ये सुनेंगे या ये मानेंगे बस.
Sir, if the coordinator could mute all of us.
Yeah. Can the coordinator mute all participants except me? Okay, this is okay. So we will discuss about the background and
सर दर्शन एक्सट्रीम लेवल पे हो रहा है. लाइट नहीं आ रही ना? उधर एसी चल रहा है.
I request everybody kindly mute yourself, please.
नहीं वैसे चिप लग रही है. गर्मी नहीं लग रही.
So firstly, the background and framework of
आवाज वो भी थोड़ी देर ना लेके हमारी आवाज भी ना जाए तो हो सकता है सो जाए.
The organizer, can you please mute everybody? Hello, the organizer, I request kindly mute.
Sir, it is from the organizer's mic only, sir, I think.
Yes, sir.
Okay, it is organizer mic. So okay, anyway, the background of framework of PPIP, then key highlights of PPIP will discuss, then overview of the process and eligibility. Then we'll discuss pre-requisition for filing application and filing of application. We'll discuss the post-initiation stage and after filing application, what will happen. We'll discuss the task of resolution professional in the process. We'll discuss the role of committee of creditors in the process. We'll discuss a very important section, section 54J in this process. Especially I want to discuss of this thing because I term J as jeopardy. Entire process may go for a toss because of the provision of this 54G. So we'll have a discussion on it. We'll discuss about the resolution plan. We'll discuss termination of the process by adjudicating authority, liquidation order by adjudicating authority, advantages of this process, concerned area of this process, and timelines for completion of PPI. And again, if time permits, we'll go for the question answer session. But I request again and again, I request you, I really appreciate the deliberation of the first half. Kindly make it live. Kindly ask me question whenever it comes to your mind. So with these things, let me start. So
Yes, sir.
I would like to discuss the background. I'll like to inform you about the background little bit in detail. You know, micro, small, and medium enterprise (MSME) are the critical for Indian economy, as they contribute significantly to GDP and employment within the country. And I am sure that all of you still carry the scary memory of COVID-19 pandemic scenario, when all of us confined ourselves within the home and the entire economic activity of the country gone for a toss. Not only our country, the entire world gone for a toss. And it not only impacts the economic activity, it impacts the health of the human beings also very much. Sure, I mean, still now we are carrying that scary experience of COVID-19 pandemic scenario, and this scenario has a very great impact on this MSME. This sector, you know, generally they are not very organized sector. And though they are the major contributor to the GDP, I think more than 80% of the GDP comes from this MSME. And also employment, more than 90%, I believe it is from MSME only. But even then, basically, they are the promotership driven companies and not very much professionally managed companies. So these pandemic scenarios impacted them very much compared to the other organized business activities or companies. So COVID-19 pandemic impacted their business operations and exposed many. As a result, many of
Admin,
them.
please mute everybody. Admin.
Yeah. And which exposed them to the financial stress and requires different treatment due to unique nature, which we have already discussed. This is not, I mean, CIRP is not the answers for them. It is felt by the government. So what's happened? Ministry of Corporate Affairs set up a committee to look into the possibility of including what is called PPAC for MSME corporate under this code, and while maintaining the business continuity and thereby preserving asset value and jobs also, employment market also. So we will discuss in details later on all these things. And the committee submitted their recommendations on 31st October 2020 to government, which the cabinet approved on 31st March 2021. The proposal to make amendments in the Insolvency Bankruptcy Code through Insolvency and Bankruptcy Code Amendment Ordinance 2021. The President promulgated this ordinance on 4th April 2021, and it said ordinance was published in the official gazette on that day, that is 4th April 2021. The pre-packaged insolvency resolution process for corporate persons classified as micro, small, and medium enterprises have been introduced from 4th April 2021. As on that, I mean, the date of notification of this process in the official gazette. The preamble of the ordinance explains the necessity of such action due to unique economic challenges that have been created by COVID-19 situation. In fact, you know, the impact of COVID-19 scenario is so heavy. All of you are aware that Government of India temporarily withdraw these IBC provisions for a period of 1 year from 25th March 2020 to 24th March 2021. There was no provision. The IBC was not applicable during this period because of the COVID-19 scenario. And also, Government of India was bound to increase the threshold limit for the CIRP application from 1 lakh to 1 crore, because the economic situation was so great that government said that there will be a surge of, financial stress. So government was compelled to increase that threshold limit. The said limit preamble also said that the primary purpose of introduction of prepackaged insolvency resolution process is to ensure quicker, cost-effective, and value-maximizing outcomes for all the stakeholders in a manner which is less disruptive to the continuity of their businesses, these MSME businesses, and with preserved jobs. So with this objective, Government of India has introduced this prepackaged insolvency resolution process with effect from 4th April through the IBC Amendment Act 2021. A prepack is an agreement in insolvency regime to offer faster insolvency resolution in an informal out-of-court settlement for the resolution of debt of a distressed company through an agreement between secured creditors and investors instead of public bidding process. You know, hey friend, this PPIRP is an alternative. It is not a separate process. It is an alternative process for CIRP, and it is only meant for as per the ordinance, that is only for MSME. So it is thought that it is informal. It is done in an informal way, and it is thought that this informal out of court settlement resolution process will be helpful for the small companies, and instead of going for the public bidding, where the invitation for resolution resolution plan is invited, others are bidding for these things. So here only the promoter, they are eligible to file the resolution plan. And also, you know, there is another unique feature of this process is that PPAC has the feature which makes the resolution process sacrosanct and has the rigor of discipline of CIRP. It is informal up to a point and formal thereafter. It blends debtors in possession with creditor in control. This is very important. These small companies, if they lose the control, they will really lose the interest of running the business. And since I have told you that this MSME has a very great exposure on the GDP of the country, so if it is happening, then absolutely the entire economic scenario will go to jeopardy. So this process, they said that, okay, here there will be no creditor in control. The debtor will be in possession of the functioning of the company, but there is a blend between the informal process up to a point and formal. There the involvement of the judiciary, that adjudicating authority after a certain stage of PPI. It allows the company, if eligible under Section 29A, to submit the best resolution plan which is exposed to challenge for value maximization. So, friend, I think you are also aware that as per Section 29A, it is mentioned that certain person, they are not eligible for submission of resolution plan, mainly the willful defaulters, or where the promoters were in respect of whom the company declared as NPA. So they are not eligible to file the resolution plan. But for the sake of the MSME, they made some changes in Section 29A. Here they have made the promoter of the MSMEs, eligible to file the resolution plan for their company. And this includes to the value maximizer. So because definitely if the promoter says that I am submitting the plan, which if approved, then it will the company will be mine again. It will come back to me again. So definitely, I mean, he will put the accurate value here. He tried to maximize the value of his assets of his company. So in that way, this PPIP process will lead to the value maximization also. It safeguards the rights of the stakeholders as much as CIRP and had adequate check and balances to prevent any misuse. It entails limited role of the courts and IPs. In fact, adjudicating, you will see that letter that adjudicating authority involved in the process after certain stages already completed. And also since the debtor is in possession, the main advantage here is that RP or IRP need not to run the company as a business of the corporate debtor as a going concern. It saves the time from them and they can put their attention in the other work of this process. So also this is an advantage in this process. The framework is that you can find the governing provisions for PPRP firstly in the Insolvency and Bankruptcy Code 2016 as amended by IBC Amendment Act 2021 with effect from 4th April 2021. Chapter 3A, section 54A to 55P has been introduced in part 2 of Insolvency Code. So code is also amended to incorporate this process. Then you will find the governing provisions in Insolvency and Bankruptcy prepackaged Insolvency Regulations, Resolution Process Rules 2021, as well as in the Insolvency and Bankruptcy Board of India prepackaged Insolvency Resolution Process Regulations 2021. So all these documents contain the provisions, the manner in which this PPRP process will be conducted. So now I come to the key highlights of the amendment. I already told that the amendment, second amendment is done in the amendment in the IBC code in 2021. So what are the key highlights of the amendment for PPIP? Let us discuss. First is that amendments in IBC were made through ordinance dated 4th April 2021 under section 4, which talks about the threshold limit, section 5, which talks about various definitions, section 11, which talks about the persons who are not eligible to file the application. Then 11A is the disposal of application. There is a very, this section contains, this is a new insertion. This section contains a very unique thing in the sense that I said that PPIP is an alternative to CIRP. It is not a separate process as such. So it may happen that the CIRP application is filed for the corporate debtor, even then the corporate debtor can go for PPIP. And how the application will be disposed of is given under section 11A. So then section 33, I will discuss that in under what scenario that PPIP process converted into a liquidation process. 34 is that appointment of liquidator. 54A to 54P, I have already told you that these are the provisions related to PPIP process given in chapter 3A. 61 Apple, 65, 67A, 77A, 208, 239, 240 and 248. All these amendments in the code brought either they modify the current scenario section provisions of the current section, or they brought the new incorporate the new sections within the code. A new chapter 3A has been added containing section 54A to section 55P under part 2 of corporate insolvency process in IBC. I already told you. New definitions under section 5 has been added. Section 4, minimum default of 10 lakhs has been prescribed for PPIP through notification dated 9/4/2021. You know, generally the threshold limit, I told that because of the COVID-19, they increased the threshold limit from 1 lakh to 1 crore. But with the notification dated 9/4/2021, Ministry of Corporate Affairs, they said that for availing the PPIP process, the minimum default amount is 10 lakhs. It is not 1 crore. So if there is a default amount for 10 lakhs, the corporator is eligible to file his application for PPI. Section 54A in Chapter 3A specifies the prepackaged insolvency process can only be initiated against the corporate debtor who should be included in the criteria of MSME. Yes. And you, I think you are aware also that, you know, that Section 7 of MSME Development Act 2006 has been modified, and now the inclusion in MSME is very large. Like your small companies, is the capital investment is 1 crore and turnover is 5 crore. Then for your micro is 1 crore and 5 crore. Small is I think 10 crores and 50 crores, and medium is 50 crores. Capital inclusion is 50 crores and turnover is 250 crores. So this has been increased. This definition of MSME is broadened to incorporate many companies within the ambit of MSME, which for which the prepackaged insolvency processes are made available. Then section 54(3) provides that section 24, which talks about the meeting of COC. 25A is the rights and duties of the authorized representative. 26 is the application for avoidance transaction will continue even then the CIP process is over or the PPR process is over. Section 27, 28, 29A, 32A, 43 to 51, that is avoidance transactions, and the provisions under chapter 4 and 7 shall apply to PPRP as well. So even if it is a separate procedures compared to CIRP, but all these provisions of CIRP will be equally applicable for the purpose of PPRP process as per that amendment. The new section 67A is inserted specifying penalty and fraudulent management of CD during PPRP, and new section, these are the new section, and new section 77A has been inserted specifying punishment for offenses related to PPRP. So these are the key highlights of the amendment made in the court through the amendment dated 2021, 4th April 2021 for the PPRP process. Okay, I told you that I really, whenever I speak about the IBC, whenever I make the presentation for IBC, I always show this slide. But for the time being, I skip it. But definitely I'll come back to it after the end of my presentation. Kindly remind me, because I like to say something, because it has definitely has the relevance to the PPRP process. But for the time being, I just skip this one. Now we come to the overview of the process. PPRP to prove PPRP is to provide an alternate, and what I've already told you, that PPRP is to provide an alternate and expedient insolvency resolution process for MSME. Stakeholders may choose one over the other in certain cases. So it is not a separate process. Even for the MSME, if the financial creditors want or the operational creditors want, they can go for CIRP. Absolutely no problem. But following this process, the advantage is that it very quickly dissolve the process, and it is better for that small companies. Even then, it is open for the stakeholders to choose whether go for CIP or PPI. The aim is to ensuring continuity of the business of the corporate debtor while efforts are made to resolve its stress. Certain prerequisites are placed in the legislation of the scheme to ensure stopping its misuse by the management of the corporate debtor. So it is subject to this application is subject to fulfillment of certain conditions, which we will discuss later. The scheme is applicable on CD classified as MSME, yes, with the minimum default amount, that is threshold limit of 10 lakhs. Section 20 I have already told you. The total time period for completion of PPRP is 120 days, while a resolution to be approved by the COC and submitted to the adjudicating authority within 90 days of the PPRP commencement date. You can see the expedient completion of the insolvency process. Unlike the 180 days, then 270 days or 330 days of the CIRP process, the timeline, the maximum time period fixed for the PPRP process is only 120 days, and even more so that the COC should approve the plan and submit to the adjudicating authority within 90 days. So 30 days for the approval of the adjudicating authority. So the for all said and done, that the entire process should be completed within the 90 days of the commencement. The management of the city shall vest in the board of directors of the partners, as the case may be. If it is LLP, then partners, company, board of directors. Unless COC directs by a vote of 66% of voting share, the management should vest in resolution professional, subject to approval of the adjudicating authority. So if required, we will come to this. If required, generally it is the debtor in possession process, not creditors in control. But what I said you earlier also, there are certain checks and balances are provided in the process to stop any unfair practices by the management. So the process said that at any time COC directs with a vote of 66% that the management should be best in the hands of the resolution professional, and the creditors will be in control of the business. The key features of the process is like that: the appointment of IP is required at the initiation stage of application. Before making the application, you have to appoint one insolvency professional. This is also good. I mean, this also reduces the time frame for completing the process. Envisages a consensual process between CD and unrelated FCs. Before filing, we will discuss it. Before filing the application, there are certain processes to be completed by the CD with the consent of unrelated FCs. Unlike your CIRP process, where after the order is passed, all these things are happening. CD remains under the control and possession of the management. The insolvency resolution process enjoys moratorium excepting on essential services. So for essential service, there is no moratorium. Otherwise, the process will enjoy the moratorium, like CIRP. Court approved outcomes binds stakeholders. All the stakeholders bound to follow the approved order of the adjudicating authority. So as I said that section 5, through this amendment, section 5 has been amended and some new definitions. Section 5 deals with the definition. Some new definitions have been incorporated in the process, in the provisions of the code. So what are these? Firstly, the concept of best resolution plan has been introduced. What does it mean? Best resolution plan means a resolution plan provided by the corporate debtor. Here the first resolution plan which comes, it is from the corporate debtor and it is called the best resolution plan under clause C of subsection 4 of section 54A. Then the new definition has been introduced for the basis for evaluation. How the plan will be evaluated. This includes basis for evaluation includes the parameters to be applied and the manner of applying such parameters as approved by the committee for evaluating a resolution plan to assign a score of the plan and disclose in the invitation of resolution plans. Friends, this evaluation is not only for the best resolution plan. This is also will come to this. It is also for the, because if there is certain things in the best resolution plan, the RP will be directed to ask for the plan from the others, and that is called the best alternative plan, BAP. So how the BAP will be evaluated as compared to the best resolution plans, BRP, that is mentioned here. That will be, so how it will be? It will be through the parameters as approved by the committee and also disclosed while those plans are invited from the other party. Preliminary information, unlike your memorandum of information, they have the preliminary information are submitted by the corporate debtor upfront. So as per the clause 54G subsection 1B. So preliminary information, it is the responsibility of the corporate debtor himself. Prepackaged insolvency date means the date of admission of an application for initiation the prepackaged insolvency resolution process by the adjudicating authority under clause A of subsection 4 of subsection 54C. Prepackaged insolvency resolution process period means the period beginning from the prepackaged insolvency commencement date, that is from the date of admission of application, and ending on the date on which the order under subsection 1 of section 54L or subsection 1 of section 54N or subsection 2 of 54O, as the case may be passed by the adjudicating authority. These subsections indicate the various stages where the prepackaged insolvency process either completed or rejected or terminated by the adjudicating authority. So there are certain formal touch also in the process, which I have told you earlier. So if these events happen from the application approval date up to that date, it is called the prepackaged insolvency process period. Then prepackaged insolvency resolution process cost. It means that the amount of any interim finance and the costs incurred in raising such finances, the fees payable to any person acting as a resolution professional, and any expenses incurred by him for conducting the prepackaged insolvency resolution process during the prepackaged insolvency resolution process period, subject to subsection 6 of section 54A. So certain conditions are mentioned in this section. Otherwise, anything fees payable and any expenses made by him will be included in the prepackaged insolvency resolution process cost. Any cost incurred by the resolution professional in running the business of the corporate debtor as a going concern pursuant to an order under subsection 2 of section 54J. Any cost incurred at the expense of the government to facilitate the prepackaged insolvency resolution process and any other cost as may be facilitated. So all these costs will be considered as the prepackaged insolvency resolution cost. And then another concept definition has been included in section 5. It is significantly better. I told you not that about the BRP, best resolution plan and best alternate plan. So how the which plan is better, that is significantly better, how it will be decided, that definitely is also incorporated in section 5. Significantly better in relation to resolution plan means the score of the resolution plan is higher than that of another resolution plan by a certain number of percentage as approved and disclosed in the invitation for resolution plan. When the RP makes the invitation for the resolution plan from outside, I mean, apart from the best resolution plan, in that invitation, as per the approval of the COC, it is mentioned that unless and until that plan is higher than this much of percentage of from the best plan, then it will not be considered. So you can understand the main interest of these things is to maximize the value of the assets of the company within a very short period. So this is significantly better. Now we'll come to the eligibility. The prerequisites for filing the application for initiation of PPRP, it is given in section 54A, which says that the corporate debtor must be classified as an MSME under section 7 of subsection 1 of Micro, Small and Medium Enterprise Development Act, MSME Act 2006, which I have already told you. And I also told you for this purpose, the classification of MSME has also gone. I mean, now the many companies are come under the ambit of the MSME because of the increase in the capital infusion and the turnover figure. There is occurrence of default of section 4 for PPRP is 10 lakhs by this notification. It has not undergone PPRP or completed CIRP during the period of 3 years preceding the initiation date. So friend, if the application under PPRP is filed, we have to see that it has not undergone under PPRP or it has not completed CIRP during the period of 3 years. So previous year there is no CIRP was done against this corporate debtor. It is not undergoing CIRP also, and not only the completion of CIRP 3 years prior to that initiation date, also it is not undergoing presently. Also it is not undergoing for CIRP. No order of liquidation under section 33 has been passed for the corporate debtor case. It is eligible to submit a resolution plan under section 29A. 29A also is very important. I will discuss with you here. So now it is prerequisites for filing of application. PPRP, if you have any question, please ask me. PPRP envisages a hybrid process where pre-initiation phase is highly informal and post-initiation stage is formal. The informality at pre-initiation stage offers flexibility for the CD and its creditors to swiftly explore and negotiate the best way to resolve stress in the business, while the post-initiation stage derives value maximization and bestows the resolution plan with the statutory protection. So what I have told you that already told you that in the pre-initiation stage, it is a consensual discussion amongst the unrelated financial creditors and the corporate debtor. And this is done in an informal way without going to SLT or without going to any adjudicating authority. But the post thing will be in a formal way. It has the legal basis. And this is because of the value maximization of the assets of the corporate. For seeking approval of creditors under section 54A, 2E and 3, the corporate debtor, that is applicant, shall convey a meeting of the financial creditors who are unrelated to him for the appointment of IP and RP. So this is the first stage. If the corporate debtor decides that, okay, I will go for the PPIRP process, this is the first stage that he has to call for a meeting of the unrelated financial creditors and tell them to appoint a IP as RP. Where the CD has no financial debt or where all the financial creditors are related parties, the CD shall convey the meeting of operational creditors who are unrelated for this purpose. For convening the meeting, a notice shall be served at least 5 days before the date of the meeting, unless a shorter time is agreed by all of them. The notice of the meeting shall indicate the date, time, and venue of the meeting and specify the agenda items for discussion. So it is the proper way of convening a meeting of the creditors for initiation of the for filing the application, initiation of the process. The CD shall enclose a list of creditors because everything is the responsibility of the CD. The CD is responsible to enclose a list of creditors and the amount due to each of them. It is in form P2. One thing I am telling you, friends, that PPIRP is a very, very formal process because everything is described. The form is described, the sections is described. So the good thing is that there is a very little chance for rejection of the application. If you follow in detail the forms, rules mentioned in the code and regulations and rules, then you can understand that your application will be admitted by the adjudicator. Anyway, so the form P2, the list of creditors to be filed by the CD, along with the notice of the meeting, declaration, the resolution, and also declaration to be filed. Declaration I will discuss. It is in form 6. The resolution of the members or the partners and the best resolution plan. So along with the notice, a list of the creditors to be filed, a declaration from the management of the city to be filed, the resolution passed by the members that they are agree for the PIP to be filed, or the partners, and the best resolution plan. You see that resolution plan is prepared by city at the time of convening the meeting. So many work which we find that are started after the admission of CIRP process, here you will see that those tasks are already completed or the starting of those works are started from the very initiation, very beginning stage. From the very beginning, those work are started. In the meeting, creditors having at least 10% of the value of debt shall propose the name of an IP eligible under the regulations for appointment as RP, as a RP. Now even he is not appointed as RP, so it is only a proposal, and this proposal is done by the creditors, unrelated creditors, of course, who have 10%, at least 10% the value of debt. An IP is eligible to be appointed as RP if he and all partners and directors of IP, insolvency professional entity, in which he is a partner or director, are independent of CD. So independency of the insolvency professional is also maintained in this process. A person is considered as independent of CD if he meets the requirement as specified under Regulation 7. It is mentioned. The creditors not less than 66% in value of debt due to such creditors shall approve the appointment of RP. First 10% was a proposal. Now for the appointment of RP, the approval should come from the creditors, unrelated creditors, with not less than 66% in value of the debt due to such creditors. With such terms and conditions, with fees payable to him for performing duties in relation to the pre-initiation phase under section 54B, fees payable to him and expenses to be incurred by him for conducting PPIRP, fees payable and expenses to be incurred by him in case management of the CD is vested with him under section 54J. So for all the circumstances, what will be the terms and conditions and fees payable to the resolution professional are determined only at the time of initiation the application for PPIRP process. So later on there is no delay, or I should say there is no litigation. No. What should I say? I mean, there is no point of contention or no litigation, no application will be filed. It will be a very smooth process. In the meeting, the creditors representing not less than 66% in value of debt due to such creditor shall approve filing of application for initiation of PPIRP. So filing of application should also be approved by the committee of creditors. Committee of creditors may say that, okay, no, we are don't agree. Maybe they will go for the filing CIRP against the corporate debt. So for filing the application, it is required the approval from 66% in value of debt due to such creditors in the meeting. The IP proposed to be appointed as RP shall ascertain creditors in classes, if any, from the list of creditors, identify 3 IPs to act as authorized representative, that is heir, and obtain their consent in Form P5, seek choice of creditors in the class, select the IP who is the choice of highest number of creditors in the class to act as heir. So what's happening? The IP, I mean, proposed to be appointed as RP. I said that IP is not yet appointed as RP. So IP who is proposed to be appointed as RP, he should go through the list of creditors, and if he say found that there are the classes of creditors there, so he will identify 3 IPs for each class of creditors and take their consent and seek the choice of the creditors, and here the approval will be taken by the majority, not by 66%. Who is the choice of highest number of creditors in that case to act as the authorized representative. The IP proposed to be appointed as RP inform the applicant that is CD the name of the heir along with his consent. So it is also we inform to the CD also. The IP proposed to be appointed as RP shall prepare report in Form 8 confirming whether CD is eligible for PPIRP and the BRP confirms the recurring. So it is again the responsibility of the IP who is proposed to be appointed as RP to prepare a report that yes, CD is eligible for PPIRP and that BRP confirms the requirements of the code. The majority of directors or partners, as the case may be, have made a declaration. I talk about that. I told you that the declaration to be filed at the time of sending the notice for the meeting. No? So what is that? What is that declaration? They have made a declaration containing the following: that CD shall file an application for initiating PPIRP within a definite period not exceeding 90 days from the date of approval of the proposal for appointment of RP. So within that date, within 90 days, they will file the application. The process is not being conducted to defraud any person. This is also they have to declare. the management, that is the directors of the partners, the name of the IP proposed and approved to be appointed as RP. This all to be declared by the CD in the declaration. The members of the CD have passed a special resolution at least of or at least 3/4 of the total number of partners of the CD have passed a resolution, as the case may be, approving the filing of application. Also, you have seen now that during the submission of the notice, we have to file the resolution. So what the resolution for the company? It is a special resolution of the member, or if it is a partnership firm LLP, 3/4 of the total number of partners that they agree approving the filing of application. That resolution to be filed along with the notice of the for the meeting of the creditors for filing the application of PPI. The CD shall prepare a best resolution plan in conformity with the requirements under section 54K. So friend, if you see 54K mentions the requirements which are to be shown in the best resolution plan. And that best resolution, that's fine. So that, PPRP process is very much formalized. Either in the code it is said what to be done, or like there are prescribing, the authority prescribes certain forms, specific form for submitting the information or details for this application. So here the BRP, that is the best resolution plan, to be prepared as per section 54K. So what I told you, if you see the eligibility, I'll just go back. In eligibility slide, I told you that person is eligible to file PPRP if it is eligible to submit a resolution plan under section 29A. So if the person is not eligible to file the resolution plan under section 29A, that person, is not eligible to file the PPRP application. So now we'll see what is mentioned in section 29A. Section 29A mentions that persons not eligible to be resolution applicant. A person shall not be eligible to submit resolution plan if such person or any other person acting jointly or in connect with such person is an undischarged insolvent. In that case, he will not be able to file the resolution plan, and then he is not eligible for filing the PPI. Then, if he is a willful defaulter in accordance with the guidelines of Reserve Bank of India issued under Banking Regulation Act 1949. This guideline says that if the person has the capability to pay the debt, but even then if he deliberately not paying the debt or interest on the debt, then he will be adjudged as the willful defaulter, and it will be considered as good as a fraud made to the banking company. See, at the time of submission of the resolution plan, has an account or an account of a corporate debtor under the management or control of such person, or of whom such person is a promoter, classified as non-performing asset in accordance with the guidelines of Reserve Bank of India issued under Banking Regulation Act 1949, or the guidelines of a financial sector regulator issued under any other law for the time being in force, and at least a period of 1 year has lapsed from the date of such classification till the date of commencement of corporate insolvency resolution process of the corporate debtor. Then, as per the norms, as per these guidelines of RBI, I think if the corporate debtor, I'm not sure very much, fails to pay interest, at least the interest portion of his debt for 3 months consecutively, then his asset will be treated as a non-performing asset. If anyone has the idea on these things, you can share. But I think this is the regulation. If fail to pay at least the interest portion of the loan for consecutively three installments, then his account will be adjudged as a non-performing asset, or as per the guidelines of the other financial sector regulator. Provided that person shall be eligible to submit a resolution plan if such person makes the payment of all the overdue amounts with interest thereon and charges relating to non-performing assets accounts before the submission of resolution plan. So there is a provision that if this happens and if the person paid the entire thing along with the interest, then he will not be considered as his asset account will not be considered as an NPA. And further, it is provided that nothing in this section shall apply to a resolution applicant where such applicant is a financial entity and is not a related party of to the corporate debtor. So for the financial entity whose business is providing the loan or its related party to the corporate debtor, then in that case, this provision will not be applicable. Okay. So explanation 1 also of section 29A says that for the purposes of this provision, the expression related party shall not include a financial entity regulated by a financial sector regulator if it is a financial creditor of the corporate debtor and is a related party of the corporate debtor solely on account of conversion or substitution of debt into equity shares or instruments convertible into equity shares or completion of such transactions as may be prescribed prior to the insolvency commencement date. So explanation 1 also said that related party will not be considered if it is under the regulated, if the entity is regulated by a financial sector regulator, and if the conversion of the loan, if and is a related party of the corporate solely on account of conversion or substitution of debt into equity shares, then also it will not be before the prior to the insolvent commitment, then it will not be treated as a related party. And explanation 2 said, for the purpose of this clause, where a resolution applicant has an account or an account of a corporate debtor under the management or control of such person or of whom such person is a promoter, classified as non-performing asset, and such account was acquired pursuant to a prior resolution plan approved under this code, then the provisions of this clause shall not apply to such resolution applicant for a period of 3 years from the date of approval of such resolution plan by the adjudicating authority. Explanation 2 said that if a prospective resolution applicant acquired the business of the corporate debtor by submitting the resolution plan which is approved by the adjudicating authority, where the corporate debtor's assets are considered as non-performing assets, that person, that promoter of the new promoter of the corporate debtor will not be considered as will not come and fall under the provisions of section 24A 29AC for a period of 3 years from the date of the order passed by the adjudicating authority. So I have not considered, I have not taken the entire section. I have only written what is relevant for our discussion, that is the PPIP process. Then H, subclause H, section 29A, H says that has executed a guarantee in favor of a creditor in respect of a corporate debtor against which an application for insolvency resolution made by such creditor has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid in full or part. So here also the person is not entitled to file the resolution plan. If he is a corporate debtor and his guarantee is invoked, he will not be able to file the resolution plan. And also, I mean, what we have already discussed, willful defaulter or undischarged insolvent, then if he is a promoter of a company whose accounts is adjudged as NPA, in all these scenarios, I mean, accepting what is mentioned in the proviso and explanation, in all such cases, the person will not be able to file the resolution plan. And if a person is not able to file the resolution plan, he lost his eligibility to file the application under PPIR. But to provide a comfort to the MSME, it is only for the MSME entity. A new section 240A was inserted by the Insolvency Bankruptcy Code Second Amendment Act 2018 with effect of 6 June 2018. And what does it say? He said that application of this code to micro, small and medium enterprises, only applicable for this micro, small and medium enterprises. Notwithstanding anything to the contrary contained in this code, the provisions of clauses C and H, what we have seen, that NPA and the personal guarantor of section 29A shall not apply to resolution applicant in respect of corporate insolvency resolution process or prepackaged insolvency resolution process for any micro, small and medium enterprises. So if the submission of plan is related to insolvency MSME insolvent company, or if the promoter is of a MSME company, then the subclause C, that is NPA clause and the personal guarantor clause, will not be applicable. So in this case, only the MSME person promoter will be free to submit his resolution plan. As a result, what's happened, if the company, MSME company, because PPRP is only open for MSME companies, if the company gone for PPRP, then if promoters are eligible to file the resolution plan of its own company. Generally in CIRP, you have seen that the promoter of non-performing assets or willful defaulter, but willful defaulter will not apply. If it is a willful defaulter, he cannot file the resolution. Yeah. So in CIRP, that NPA, the promoter of the company whose assets are adjudged as NPA, or the personal creditors of that company, they are not allowed to file the resolution plan for the CIRP process. But here they said it is allowed. Explanation: for the purpose of this section, expression micro, small and medium enterprises means any class or classes of enterprises classified as such under subsection 1 of section 7 of Micro, Small and Medium Enterprises Development Act 2006. So friend, it is clear. Am I clear to you? Hello?
Yes, sir.
Yeah,
Absolutely.
interesting.
That's very interesting.
Thank you, sir. Now we come to filing of application. What are the prerequisites for filing the application for PPRP process? So what is said, only a corporate applicant can file an application to initiate for initiation of PPRP. PPRP cannot be filed by the creditors or operational creditors or the financial creditors. He must be the corporate applicant. That is, CG is only allowed to file PPRP. The application should be filed in Form 1 before adjudicating authority and submit a copy of the application to IBBI before filing with the adjudicating authority. So another condition is that the corporate debtor, while filing the application, should file a copy prior to submission, his submission to adjudicating authority to IBBI. The following documents are required to be attached with the application. So list of documents, what I said that this is really very advantageous for the PPRP process because many work is done prior to filing the applications. So no doubt that the very short time has been fixed for the completion of the process. So what are the documents the CD is required to file? Firstly, the record of default. How the default comes. The consent of the IP proposed to be appointed as RP in Form P1. The approval of creditors non-related parties for initiation in Form P4. All the forms are prescribed, what I told you. Consent of the IP proposed to act as heir, if any, in Form P5. The declaration of by the director partners that it is not done to default any creditors in Form P6. The members resolution, that is special resolution passed by the members or partners resolution, that is 3/4 value of the partners, 3/4 numbers of the partners. Declaration by CD regarding avoidance transactions in P7. The CD has to declare that there is no avoidance transactions exist in its company. It is a very, very important thing. And if anything, any contravention is found, I have told you that new sections 67A and 77A has been incorporated to penalize the management, the person who is at fault. The report of IP that CD is eligible for application, or also the BIP, BRP is in conformity with section 54K, and that report is to be filed in Form P8. The audited financial statement of last 2 financial years to be filed along with the application. Provisional financial statements for current financial year made up to the date of declaration under section 54A to F. That is also to be filed. And importantly, it is to be filed that the latest and updated Uddam registration certificate. You know, when a MSME is registered by the Ministry of MSME, they issued a certificate which is called Uddam registration certificate. So the latest and updated copy of that registration certificate should be attached along with the application or the proof that CD is a MSME. I think, now you know what's happening. The authority, adjudicating authority, always insist upon this certificate, not the proof. So it is better that one should register himself under that under MSME Act and obtain his Uddam registration certificate before filing his application. Then one affidavit stating that the CD is eligible under section 29A, what we just discussed, of the court, and submit resolution plan in PPRP, and these things to be submitted along with in a affidavit form, that is with oath. A statement of affairs made up to a date not earlier than 14 days from the date of application. A statement giving the names and addresses of the members or partners of the CD with the details of their shareholding. So the details of the members or partners along with the shareholders should be attached with the application. Proof of payment of application fees, that is to be given. proof that a copy of application has been submitted to IBBI. So I said that before prior to submission of application, a copy should be submitted to IBBI upfront, and the proof of that submission to be attached to the application. The document that records the authority of the applicant is to make the document that records the authority of the applicant to make the application, whether the applicant is a member or partner of CD. So if a member or partner of the CD is making this application, then he must produce the authority, maybe a board resolution or maybe the partner's resolution, that he is authorized to make this application on behalf of the corporate. That is also required to be attached along with the application for PPI. So after receive the application, what's happened? Within 14 days of the receipt of the application, the AA shall submit the application. The AA shall submit the application if it is just so within 14 days of the receipt of the application, the AA shall admit the application. Sorry, the AA shall admit the application if it is complete or reject the same if incomplete. So within 14 days, the AA will give its order, either by accepting it or by rejecting it. However, if it is rejected by AA, the AA shall provide a period of 7 days to the applicant for making the necessary rectification of defects. So defects will be told to the applicant and he will be given 7 days time to rectify those defects and to resubmit the application for approval. If it cannot be done, then it will be stand as rejected. So PPRP shall commence on the date of admission of application. When the application is admitted, the commencement date for PPRP will start. The A shall on PPRP commencement date along with the order of admission declare a moratorium under section 14A, 14(1) and 2 of the code, appointment the RP named in the application as RP. Now the RP is appointed. Earlier, what we have discussed, it is the proposal by 10% of financial creditors, approval by 66% of financial creditors, but the real appointment of RP is made by the adjudicating at the time of delivering the order for approving the PPRP application. So name in the application as RP and cause the public announcement to be made by the RP. And also ask RP that you make a public announcement for asking for the claims of the corporate. The duties of the IP shall cease if application is either not filed within the time specified, that is 90 days, or in declaration in Form P6, or not admitted by the adjudicating authority. So if there is a delay in filing the application, or if the application is rejected, then IP will, the function of IP will come to an end. IP will not be considered as an RP for this purpose. He will be remain as IP. Clear? I am clear. So RP can only be appointed by the adjudicating authority. Otherwise, the entire work is done by the insolvency professional, not by the resolution professional. Now also it is a very important thing which I have already told you, that PPIRP is an alternative procedure, alternative process. It is not a separate process. So either the company can, the creditors can go for the CIRP, or the PPIRP, they accept the application under PPRP by the corporate. So now what's happened? This section 11A, this is inserted by the Insolvency and Bankruptcy Code Amendment Ordinance 2021 with effect from 6/4/2021. It mention how the applications under PPRP and CIRP will be disposed of. The company has already filed the application for CIRP. It doesn't prevent the person, if it is consented by the financial creditor, to apply for the PPRP. But how the application will be disposed of is mentioned under section 11A. How it is done? Where an application filed under PPRP is pending, the A shall pass an order to admit or reject the same before considering any application filed under CIRP under section 7, 9 or 10 during the pendency of PPRP application. So suppose the PPRP application is filed first and then the application is filed for the CIRP. It is possible because this is an alternative method. But the adjudicating authority should dispose of the pending PPRP application first, and then and shall pass an order to admit or reject it the same and before considering the application. So if it is approved, then that application under CIRP will be rejected. So the first preference will be given to the PPRP application because it is for the MSME sector. Where the application under PPRP is filed within 14 days of application of filing an application under CIRP in respect of the same CD which is pending, then adjudicating authority shall first dispose of the application of PPIRP. So now consider another scenario. You know what's happened? That application for CIRP has been filed and application for PPIRP also filed for the same CD, and it is filed within 14 days of the filing of application under CIRP. So in this case also, the adjudicating authority first dispose of the application of PPI. Either the adjudicating authority will admit the application or reject the application, but then the application under CIRP will be considered. Here. And third scenario, what's happening? Where an application for PPIRP is filed after 14 days of filing an application under CIRP in respect of the same CD, the CD shall first, the A shall first dispose of the application filed under CIRP, but there is a but here. If an application under CIRP is pending as on 4/4/2021, when this ordinance came into effect. So if it is pending as on that date, the date of the scheme when the PPIRP was notified, this provision will not apply. So in that case, even if PPIRP application is filed after 14 days, the adjudicating authority will dispose of the PPIRP application first, and then he will take the application for CIRP. Otherwise, the authority will first dispose if it is after 15 days filing of 14 days of filing of CIRP application. The adjudicating authority first dispose of the CIRP application, and then the adjudicator will consider the PPIRP application. Okay. So this is as per section 11A. It shows how the disposal, how the applications under PPIRP and CIRP file will be disposed by the adjudicating authority. Now, friends, I mean, till now we are discussing about the filing of application. What are the procedures? How it will be filed? I mean, what is the requirement? That is the prescribed form, sections, everything. These are all related to the pre-initiation stage of PPIRP process. Now we come to the post-initiation stage. You know, after the approval is admitted by the adjudicating authority for initiation of PPIP, what are the steps to be followed? We will discuss those things now. So what is mentioned here? The PPIP processes are required to be completed within a period of 120 days from its commencement date. That is when the order is approved, the application is approved. From that date, 120 days, within 120 days, period of 120 days, that entire process of PPIP should be completed. And as I already told, that within this 120 days, the approved plan, approved resolution plan, whether it is BRP or BAP, has to be filed by the resolution professional within 90 days from the date commencement. And balance 30 days is for the adjudicating authority to approve the process or reject the process. But it is only 120 days and there is no provision for the extension of time. During PPIRP, the management of the affairs of CD shall continue to vest in the board of directors, the partners of the CD. The board of directors, the partners of the CD shall make every endeavor to protect the value of the property of CD and manage its operation as a going concern. It is no more the duty of the RP. It is the duty of the board of directors or the partners to continue the business of the corporate debtor as a going concern. The promoters, members, personnel, and partners of the CD shall exercise and discharge their contractual and statutory rights and obligations in relation to the CD. So unlike in CIRP, where it is mentioned that all of them will report to RP, it is said that they will discharge their contractual or statutory rights and obligations in relation to the CD by their own. So what they are doing earlier, they will keep on doing after the approval of the PPIP application also. The CD shall within 2 days of PPIP commencement date submit to RP updated as on the date the list of claims along with details of respective creditors, their security interest and guarantees in Form P10. A preliminary information memorandum containing information relevant for formulating a resolution plan. And you see, since the management of the CD is with the corporate debtor, with the promoter or the directors, and they have the possibility to get back their business by their own. So unlike CIRP, there is no such problem in receiving all these documents in time. So list of claims to be filed within 2 days and also a preliminary information memorandum containing information relevant for formulating a resolution plan. The CD shall provide to the RP within 2 days from the date of commencement of PPI. Sorry. If any loss or damage is sustained as a consequence of the omission of any material information, it is very important, or inclusion of any misleading information in the list of claims or in the PIM, that is preliminary information memorandum, every person who is a promoter or director or partner of CD at the time of submission of the or the person who has authorized such submission shall be liable to pay compensation. I also, when I started my overview, I said necessary check has, though it is the debtors in possession process, but necessary checks and balances have been introduced in the process to debar any malpractices by the management of the corporation. So if there is any misleading information, is not the proper information is given, if PIM is not properly drawn, the person who has authorized or who has prepared, he will be liable to, and if any loss is suffered or damage is sustained, the person who is responsible for this or who has authorized for this submission will make good that damage or loss. He has to pay the compensation. The CD shall submit the BRP to RP within 2 days of PPRP commencement date. Again, you see the list of creditors, preliminary information memorandum, as well as the people, because all these are prepared at the time of filing the application, and that is the really beauty of PPR. You need not to waste any time for the actual process to start. Everything is prepared before the filing the application. So CD shall submit the BRP to the RP within 2 days of PPRP commencement date. BRP may be revised if permitted by the COC. So COC can permit the CD to revise the BRP. Yes, it is. Agreed. Allowed. The RP shall make a public announcement in Form P9. Again, the form is prescribed within 2 days of the commencement date in the manner specified in Regulation 9. RP shall exercise powers and carry out duties as required under Section 54F. Now we'll see what are the tasks to be performed by the resolution professional. Firstly, the resolution professional should give consent to act as RP if eligible under regulations. So you know the regulations. Now, when the insolvency professional is eligible to act as RP, if he is independently not related to the city, if he is independent, if there is no disciplinary action lying against him, all these things. So if he is eligible under the regulations, he will give assent to act as the RP. A certain class or classes of creditors, if any, seek choice of the creditors in the class for an IP to act there. Yeah, friends, one thing I'm telling you, this is the class of resolution professional as well as an insolvency professional, because you know when this thing is done, the resolution professional is approved. Insolvency professional is approved as resolution professional by the 66% vote of the financial creditor, but he has not approved as such by the order of the adjudicating authority. So according to me, all these tasks are done by the IP. A certain classes of creditors in any, if any, seek choice of the creditors in the class for an IP to act as heir, inform the name of the IP selected by creditors in the class along with his consent form to the applicant. So the authorized reference is also chosen by the insolvency professional, or named as resolution professional for the CD. Collect all information relating to asset, liabilities, finances, and operations of the CD. It is also his task. Prepare and submit the report in Form 8, confirming that CD is eligible for PPRP and the BRP conforms to the requirements. It is very important, friend, because he will not act as an post office. He will not simply collect the forms or the BRP and submit in Form 8. He has to put his mind. He has to confirm. The RP, IP or RP has to confirm that the CD is eligible. He has to verify all this requirement, eligibility requirement, Section 29A, all these things he has to verify. And BRP also, that it confirms the requirement as per the code. Then make public announcement. Yes. Appointment of registered valuers. It is also the task of the resolution profession. Confirm the list of claims and update it. Constitute the COC, convene the meeting of and chair the meetings. Submit IM to members of the COC. Invite prospective resolution applicants to submit resolution plan. If COC does not approve the BRP or BRP impairs some amount for the OC, then COC cannot approve the BRP. Conduct the process for improvement of resolution plan. I said that it is again once the application once the BAP best alternate plan is received, then there are certain mechanism by which the two plans are compared with the aim to for the value maximization. So that process is also the task of the resolution. Conducting that process is also the task for the resolution professional. Present to the COC for his evaluation compliant resolution plan. Submit the resolution plan approved by COC to the adjudicating authority along with compliance certificate in Form P2. This compliance certificate is required to be given by the resolution profession. Submit the application for termination of PPRP when approved by COC. So if COC wants to terminate for any reason, I will discuss these things. There are certain reasons when COC may terminate the PPRP process after its initiation also by passing the resolution of through 66% of voting right. That application for termination application of PPRB should be submitted to the adjudicating authority by the resolution profession. Form an opinion and make determination about avoidance transaction and file applications. Another important word for RP. Friends, it is debtor in possession, everything is okay. But the requirement, that's why I in my initial slide I told that it has that checks so that the resolution process comes out as a sacrosanct. So the RP, it is also the responsibility or task of the RP to determine about the avoidance transactions and file applications for that, which will be evident from the BRP, because BRP includes the information which also show the past transactions done by the corporate debtor. So a careful notice of the BRP will help the RP to determine the avoidance transactions and file applications thereof. Attend meetings of the members, board of directors and committee of directors or partners of the CD. So RP will attend all the meetings, the members meeting, the board of directors meeting, the committee of directors meeting, or the party of the CD. Not only the COC meeting where he is the chairman, but all these meetings will also be attended by the RP. Monitor management of the affairs of the CD. Though the control is with the CD, but RP has to monitor the management. The report to COC in the event of breach of any obligations of the board of directors or partners of the CD. That is also the task of the resolution profession. Manage the affairs of the CD when AA approves the application vesting management of the CD. We will come to this, but under certain scenarios, what's happened? Adjudicating authority passes the order stating that, look, the COC has applied that they want that the management of the, since the operation of the corporate debtor is not conducted in a proper way. So COC with some percentage of voting passed the resolution that the management of the affairs will now be vested in the hands of the resolution professional. Creditors control. So this is the manage the affairs of the corporate debtor when this order was passed is also the task or responsibility of the resolution professional. So friends, generally these are the tasks and the resolution professional. If you see the role of the committee of creditors in this process, it is like this. COC shall comprise of unrelated financial creditors of CD, unrelated operational creditors. If there is no financial creditor or unrelated financial creditors, then the unrelated operational creditor will form the committee of creditors within 7 days of PIRP commencement date. So this COC will be formed within 7 days of PIRP commencement date. The COC should be constituted based on the list of creditors provided by CD and verified by RP. Not only just accepting the list from the creditors, RP should verify it, and based on that, RP will form the committee of creditors within 7 days. Approve the name of IP to act as RP and his terms and appointment. We have already seen. This is also the pre-initiation stage. Select an IP as heir to represent the creditors in a class. Approve filing of application for initiation of PPIRP. Assist the RP to finalize the list of claims. Consider the BRP and allow opportunity for division. So COC role is to see the BRP, and if they found that any division is required, they will ask the CD that to make the necessary revision or changes in the BRP. Approve eligibility criteria for prospective resolution applicants. So I have already told you that if the BRP based resolution plan is not acceptable to the creditors, committee of creditors, they can ask RP to invite the others, outsiders, third party, to submit the resolution plan, and for this purpose, the eligibility criteria to be approved by the committee of creditors. Also, the committee of creditors approve the basis for evaluation, how it will be evaluated, that plan submitted by the third party. Approve significantly better in relation to the resolution plan. What are the criteria which will make the BAP as a significantly better than BRP? This criteria is also to be approved, determined and approved by the COC. Specify parameters for the improvement process of such as value for identifying the significantly better plan, tick size, the time limit for every iteration of the challenge process. You know, tick size is what's happening. Suppose BRP is made for 100 rupees. So tick size is that committee of creditors can say that, okay, we are inviting plan from others, but if that plan is less than 150 rupees, then it will not be considered. This 50 rupees, that additional amount of the BRP, is called the tick size. Tick size is the quantum based on which the fresh plan or the BAP, best alternate plan, will be prepared. So that tick size will be determined and approved by the COC. Also the improvement process, how the, I mean, suppose when the BAP received, then it will the CD will be asked to improve his BRP. If it is improved, if it matches the BRP, then how the BAP will again be improved. That improvement process will be also be identified and approved by the COC in this process. All these things are done. I think you heard about that Swiss challenge method. Now, all these things are done according to the Swiss challenge method, and as per regulation 36 of the PPRP regulation, Swiss challenge method is allowed in case of PPRP. But in case of CIRP, Swiss challenge method is not mentioned in the regulation. Only regulation 39(1)(a) said that if it is mentioned in the invitation for the resolution plan, then only the COC can increase the value of the plan through a challenge method. Whereas it is inbuilt in the process, this Swiss challenge is inbuilt in the process of PPI. Evaluate the resolution plans presented by the resolution professional and select the resolution plan amongst them. Yes. May resolve to vest the management of CD with the RP. It is purely the decision. Earlier we have seen that it is the role of the RP to act as the RP, but this will be vested in the hands of the RP. This decision is taken by the COC. May resolve to initiate a corporate insolvency resolution process in respect of the CD. It is also possible. COC can pass the resolution with that 66% voting right and can say that, look, we want that PPR will be terminated and we will pass, we will continue with the CIRP process for the CD. In that case, you know what's happening if it is approved by the adjudicating authority. The PPRP commencement date will be considered as the CIRP commencement. And all the costs incurred at the time of PPRP process will be considered as the CIRP cost. So this is a very extreme case, but the provision is that. That's why it is said that some informal process, but backed by the formal process, is also given in this PPI. Now, what I said that I will discuss with you this particular section. There are other sections also where I have just give the references. I didn't discuss because the paucity of time in detail with those sections. But I want to discuss with you this particular section, this 54J, where I term this J as jeopardized. The entire PPIRP will be jeopardized by the provisions of this section. And this section is the most draconian, has the most draconian provisions amongst all sections in PPIRP process. And the first formal touch, that is legal interference, I mean, in two sense, that IRP, I mean, the adjudicating authority will make an hearing, give his verdict, all these things. The first formal touch comes through section 54J. Otherwise, okay, adjudicating authority approved all these things, but this is not a formal legal interference. This 54J is the first formal legal interference called in the PPRP process. So what does this 54J says? This 54J is for vesting the management of corporate debtor with resolution professional. We have discussed already that in under certain scenario, the committee of creditors may pass the resolution that now it will not be a debtors in position scenario, it will be creditors in control scenario, and the management of the corporate debtor will be vested in the hands of the resolution. And this is covered under section 54J. That's why I'm saying that this is jeopardy. Enter the intention of the PPRP is jeopardized by this section. So where the committee of creditors at any time during the prepackaged insolvency resolution process period by a vote not less than 66% of voting shares resolves to vest the management of the corporate debtor with the resolution professional. The resolution professional shall make an application for this purpose to the adjudicating authority in such form and manner as may be specified. I have already mentioned in my earlier slide that RP's task or role is to monitor the activities of the corporate debtors, and if there is any breach in the function of the management of the corporator, he should inform the COC about it. And based on that report, if the corporate debtor is of the opinion by passing a resolution with 66% of voting share that now they want that the management of the corporate debtor will now be vested in the hands of RP, the RP shall make an application before the adjudicating authority in such form and manner as may be specified. What is that? On an application made under subsection 1, if that adjudicating authority is of the opinion that during the prepackaged insolvency resolution process, the affairs of the corporate debtor have been conducted in a fraudulent manner. So all this information to be provided to the adjudicating authority to form his opinion. So that's why I'm saying this is the first legal interference where the litigation in two sense comes into picture. There has been gross mismanagement of the affairs of the corporate debtor. Shall pass an order vesting the management of the corporate debtor with the resolution professional. Then, notwithstanding anything to the contrary contained in this chapter, the provision of section 2 and subsection 2 and subsection 2A of section 14, that is moratorium, will be applicable for this vesting of the management with the resolution profession. Similarly, the section 17, that is management of the affairs, will be now conducted by the IRP. It is mentioned in the adjudicating will allow the IRP to manage the affairs of the CD. The clauses E to G of section 18, duties of IRP will also get attracted by this order of the adjudicating authority. Section 19 and 20, that is cooperation of the management and cooperation from the personnel of the CD and the management of the CD as the going concern will also be attracted with this order. So, friends, for all practical purposes, the CIRP process will be started with this with the order under section 54G. Subsection 1 of section 25, duties of RP, clauses A to C and clause A of subsection 2 of section 25, immediate control of assets, interim finance, and section 28, that is up to certain cases where the approval of COC is required, shall mutus mutandis apply to the proceedings under this chapter from the date of the order under the subsection 2 until the prepackaged insolvency process period comes to an end. So the basic idea that it will be in the hand of the corporate debtor, and they can control their business along with the process will get jeopardized. Process will continue, but everything will be in the hands of the RP after approving the approval of section 54G. Is it clear, sir? Hello? Hello, I am clear to you. Hello?
Yes, sir, you are audible.
Yeah, I am audible now, but this things what I am saying is clear. Okay. So now we come to the resolution plan. So what is mentioned that apart from being in conformity with the provisions of section 31 and 30 and 2 of IBC, that is section 54 cases, the 31 and 30 subsection 1 and 30 subsection 2, friend, you will remember this is applicable for CIRP also. So what section 54A said that it has to, the resolution plan for PPRP should also will be in conformity with these provision, two provisions, where that adequate provision should be made for the, it should be in conformity with all the provisions of the law of the land. Then the adequate provisions should be made for the operational creditors and the dissenting financial creditors, etc. Everything to be maintained in this resolution plan for PPRP also. But in addition to these things, there are certain mandatory contents which are prescribed by 54K for the purpose of the preparation of resolution plan. And what are these? This is an affidavit that the resolution applicant is eligible to submit resolution plan for the corporate data. A statement giving details if the resolution applicant or any of its related parties has failed to implement or contributed to the failure of implementation of any resolution plan approved by the adjudicating authority at any time in the past. So this information should also be provided along with the in the resolution plan, along with the provisions of section 31 and 32. And undertaking that every information and records provided in connection with or in the resolution plan is true and correct, and discovery of false information and record at any time will render the resolution applicant ineligible to participate in any resolution process under the code. The resolution plan is required to further provide the following: the terms of the plan and its implementing schedule, the management and control of the business of CD during its term, adequate means for supervising its implementation. So all these things to be mentioned in the resolution plan. The resolution plan should demonstrate, but it should demonstrate that it has addressed the cause of default. So what is the cause for the distress, financial distress of the corporate debtor should be demonstrated by the corporate debtor in the resolution plan. The cause, that it is feasible and viable. That plan is really feasible. What is they have prepared, it is feasible and viable, not only by saying, they have to demonstrate, they have to identify the reasons for their saying so. That it has provisions for its effective implementation. That it has the provision for approvals required and timeline for the same. So if any application approval is required subsequently, this is not only because this format is not only for your DRP but also BAP, or the plan is submitted by the outside third party. So third party, that resolution plan as a whole must mention that if any approval is required from the statutory authority, how the approval will be obtained and the timeline by which date those approvals will be received for implementation of the plan. That the resolution applicant has the capability to implement the resolution plan. That is also to be demonstrated in the resolution plan by the applicant. Statement as to as to how it has dealt with the interest of all the stakeholders, including financial creditors and operational creditors of city, that is to be mentioned in the plan. The amount payable under a resolution plan to OCs shall be paid in priority over financial creditors. To FCs who have a right to vote and did not vote in favor of the resolution plan shall be paid in priority of the financial creditors who voted in favor of the plan. So what I have said that what is mentioned in section 32 is also to be mentioned, indicated in the resolution plan. Regulation 44 of PPRP regulations further provides as follows. A resolution plan shall provide for the measures as may be necessary for maximization of value of its assets, including the following: transfer of all or part of the assets of the corporate debtor to one or more persons, sale of all or part of the assets whether subject to any security interest or not, restructuring of the corporate debtor by way of merger, amalgamation or demerger, the substantial acquisition of shares of the corporate debtor, cancellation or delisting of any shares of the corporate debtor if applicable, satisfaction or modification of any security interest, curing or waiving of any breach of the terms of any debt due from the corporate debtor. So if any onerous terms is there, so that should be waived, or that should be mentioned for the waiving. Whether it will be done or not, it is depends upon the COC while approving the plan. Reduction in the amount payable to the creditors, extension of a maturity date or a change in interest rate or other terms of a debt due from the corporate debtors. So regulation 44 says that all these things to be provided in a resolution plan. Amendment of the constitutional document of the corporate debtor, issuance of securities of the corporate debtor for cash, property, securities, or in exchange for claims or interest or other appropriate purpose, change in portfolio of goods or services produced or rendered by the corporate debtor, change in technology used by the corporate debtor, and obtaining necessary approvals from the central and state government and other authorities. So friends, if you have the assignment for preparation of the resolution plan for a PPRP application, PPRP process, sorry, all these things you have to take into account for the necessary of the resolution plan in the process. Now we come to the approval of resolution plan. If BIRP does not impair claims owed to operational creditors, the COC may approve it for submission to adjudicating authority. I have already told you that if BIRP said that okay, everything of related, due to the operational creditors will be paid, COC may approve it, not shall, may approve it and submit that. COC may agree and they can submit the BIRP as such to the adjudicating authority for its approval. If COC does not approve the BIRP or BIRP impairs the scheme of OCs, the RP shall invite prospective resolution applicant to submit resolution plans to compete with the BIRP. Now, if it is not approved or if it impairs the claims of OC, then COC may direct RP that you invite from the prospective resolution applicant the resolution plan, and that plan will be completed with the BRT. But we already discussed about the Swiss challenge method. He shall publish brief particulars of the invitation for resolution plans in Form P11, but not later than 21 days of PPIRT commencement date, in accordance with Regulation 43. So this process to be done within 21 days of PPIRT commencement date, and the prescribed form is also mentioned in the regulation. The invitation for resolution plans shall detail each step in the process and the manner and purpose of interaction between RP and the resolution applicant, along with corresponding timelines. It shall include the basis for evaluation, how the BAP, that plan is called BAP alternate plan, how the BAP will be evaluated, that basis will be included, the basis for considering a resolution plan significantly better than other resolution plan, the tick size, what we have already told you, the quantum of money which should be increased as compared to the BRT, the manner of improving a resolution plan. It shall not require any non-refundable deposit for submission or along with the resolution plan. So there should not be any non-refundable. Anybody can submit that plan, provided he has fulfilled the criteria which is given by the COC for the third-party resolution application. So now it is the evaluation of resolution plan. Firstly, we have approval. We have seen that it is can be done, but if it is not, we are not given, the third party plan is invited. Now, how it will be evaluated? Regulation 42 of PPRP regulations provide clarification with respect to the manner of scoring and improvement of resolution plans that may be adopted by the COC. The regulation provides for the following. First, the regulation 42 says the basis of evaluation. This will be approved by the basis of evaluation will be approved by the COC and shall include the parameters to be applied and the manner in which the parameters will be applied for evaluating a resolution plan to assign scores to the resolution plans. The details of the basis of evaluation shall be disclosed in the invitation of resolution plans. When the RP make the invitation to the third party applicant, resolution applicant, for the submission of their resolution plan, the basis of information evaluation which has upfront prior to that approved by the COC, by mentioning all these parameters that should be given to the in the invitation. Significantly better, that score of the resolution plan is higher than that of another resolution plan by certain number or percentage as approved by the COC as disclosed in the invitation for resolution plans. Another thing, it is not only the basis of evaluation. After evaluation, I put some scores, and if the number which I put for that resolution plan which I have received, how much it will be more than the best resolution plan, that number or percentage, or what is the percentage by it is better, so that it will be considered by the COC, that significantly better number or percentage should also be incorporated in the invitation for the resolution plan. Then tick size. What I have mentioned, that means the minimum improvement over another resolution plan in terms of score as approved by the committee and disclosed in the invitation of the resolution plan. That is the quantum of money, how much is there, so that the more score can be obtained by the third party resolution plan. That is also to be mentioned in the invitation. So the basis of evaluation, the yardstick for the adjudging the significantly better and the tick size. These 3 elements are to be mentioned in the invitation for the resolution plan as stipulated under regulation 42 of the PPIFP regulations. Then approval of resolution plan. The resolution plans received in response to invitation and complying with the requirements of the code and the regulation shall be evaluated on the basis of evaluation, which is already approved, and make it known to the applicant. Resolution plan which gets the highest score shall be selected as the best alternate plan for competition with the BRT. So all the plans received, they are scored, and the plan which got the highest score will be considered as the best alternate plan. And now this best alternate plan will be compared with the best resolution plan which was submitted earlier by the CD. The COC may consider BRP for approval if no resolution plan is received. Okay. So in two scenarios, COC may consider BFP. One, if there is no impairment of the claims of the OCs, or if COC doesn't have any plan from the third party, then also the BRP may be considered approved by the COC and submit for its approval. The COC may consider the BOP for approval if it is significantly better than the BRP. If it does not approve a significantly better BAP, the process terminates. Here is also another very interesting point. You know what's happening? We always say it is the wisdom, commercial wisdom of COC. But according to me, there is a bit deviation in the PPIRP process. So what it is said that COC may consider BOP as for approval if it is significantly better than BRP. Definitely, BAP, the best alternate plan, is significantly better than BRP, and it is not merged by the CD. So COC approve that plan. But if it does not approve a significantly better BAP, he has no option to approve the BRP. And in that case, the process terminates. The entire PPIRP process will be terminated. Friends, it is clear to you. So here the commercial wisdom of COC will not work, because it is mentioned in the code itself. Okay. If the BAP is not significantly better than BRP, the RP shall disclose the source of the BAP to BRP to submitters of these plans and invite them to improve their plans in accordance with regulation 48. So, okay, fine. Regulation 48 says that if BAP is not significantly better, then RP can disclose what is there in the BRP and ask the submitter if they are agreeing to improve their plan so that their plan will be accepted. The process of improvement shall continue till either the submitter fails to use the option within the specified time. The resolution plan having higher score on completion of process of improvement shall be considered by the COC for approval. If COC does not approve it, again the process terminates. So we found two scenarios where the PPRP process terminates. One where the BAP is significantly better than BRP, even then the COC is not approving the BAP. And if the BAP, if the BRP, I mean, third party resolution applicant does not match the BRP or fails to match the BRP within a stipulated time, and the plan which have the higher score, not only BRP, the BAP maybe it is not matched with the BRP, but it has the higher score, because you know there are other elements also. Basis of violation, tick size, all these things are there. So if a plan has the higher score, of maybe it is BRP also, in the completion of the process of improvement, but COC does not approve it, then also the PPIRP process will terminate. There is slightly difference between CIRP and PPIRP in this respect. You agree, friends? Hello, any question you have? Hello? I think I'm audible.
Yes, sir, you're audible.
Oh. So now we come to the termination of the process by adjudicating authority. So there are several cases where the termination of the PPRP order for the termination of PPRP process issue made by the adjudicating authority. Number one, where no resolution plan approved by COC within 90 days. So I said now that though the total time frame is 120 days, but RP has to file before adjudicating authority the approved resolution plan by the COC within 90 days. And where COC failed to approve the plan within 90 days, the adjudicating authority passed the order to terminate the PPI. The selected resolution plan BAP rejected by COC. What we just saw, that the significantly better BAP, but even then COC refused to accept that thing, the plan, then the process will be terminated. A rejects the resolution plan approved by COC as submitted before him. A also has the power that suppose COC approved one plan and placed before the A has the power to reject it as per the provision of the code for PPRP. And in that case, it may order for the termination of the PPRP process. Otherwise, what I say that COC with 66% voting share resolved to terminate the PPIRP process, and COC with 66% voting share resolved to initiate CIRP process. So in both the cases, PPIRP process will be terminated, and in the second case, that is 66% voting share reserved to initiate CIRP, the CIRP process will be initiated for the corporate debtor, where the AA passed an order for vesting of management to CD with RP, and COC approved a resolution plan which does not result in change in management of control of CD. In that case also, the AA may reject that plan and terminate the process. Okay. Friend, there is as such no provision for the automatic liquidation of the corporator under PPR. So even if the PPRT plan is terminated, it will not go for liquidation, except in one case, that is provided under section 54L4, which states that notwithstanding anything to the contrary contained in this section, where the AA had passed an order vesting management of CD in RP and COC approves a resolution plan, does not result, which I told you just now, does not result in change in the management or control of CD to a person who was not a promoter or in the management or control of CD, the AA shall pass an order rejecting the resolution plan, terminating the PPRT process, and passing a liquidation order in respect of the corporate debtor as referred to in subclause 1, 2, 3 of clause B of section 1 of subsection 1 of section 33 of IBC, and declaring the PPRT cost, if any, shall be included as part of the liquidation cost for the purpose of the liquidation of the corporate debtor. So liquidation under PPIP process scheme can only be done or can only have by the order of adjudicating authority. The financial creditors cannot, or any creditor cannot ask for the liquidation of the corporate debtor on the termination of the PPIP process. And it is mentioned in section 54L. So can you have some break here? 5 minutes break. Hello?
Yes, sir. We can have 10 minutes break. We can meet 4 p.m. Okay.
4 p.m. will it, right? Okay.
Yes.
Thank you. Can we start now?
Yes, sir.
Okay. So now we discuss the advantages of PPRP over CIRP. I have already told you that PPRP is not a separate process, but it is an alternative to the CIRP process, and it is only made available for the MSME corporate debtors, not for all. So PPRP is a comparatively simple procedure, has been prescribed in Chapter 3A, Section 54A to 54B in Part 2 of the Insolvency Code. And one of the beauty of PPRP, what I also said, told you, that the entire procedure of PPRP are either covered in the code itself through various sections, or it is covered under the regulations framed by for the PPIP process. So if you follow the process, I mean, you need not to worry about how to submit this information or how to prepare this statement. Everything is mentioned either in the code, your area of work, or the submission of document in the regulations prepared for this purpose. So therefore, PPIP has the following inherent advantages over CIRP. Firstly, we have already discussed that preliminary work already done. Hello, my presentation is okay. It's visible. Can you see my presentation? Hello.
Yes, sir. It's visible.
It's visible, no? Sorry. So firstly, preliminary work already done before filing application to adjudicating authority. We have already seen that at the time of initiation of the pre-application stage, many things are done, including what BRP also. It is prepared, it is done. So CIRP does not involve any preliminary steps before filing application to adjudicating authority. However, PPIP process commences only after at least 66% financial creditors approve proposal for PPIP and approve name of resolution profession. Corporate debtor passes special resolution on 75% of members approve. Corporate debtor prepares a best plan, and the name of the resolution profession has been approved by the financial creditors and corporate debtors. Thus, initial spread work is done before making application to adjudicating authority, and some sort of informal understanding has been reached with the financial creditors. So this is one of the advantages of following the PPIP process. Then informal understanding with creditors before making formal application to adjudicating authority for approval. PPIP allows creditors and debtors to work on an informal plan and then submit to adjudicating authority for approval. As such, it is a joint application, because we have seen that, when creditors consider the BRP, they allow the CD to revise the plan. So it is more or less, I mean, both the party agrees with the plan. It is a joint application by the corporate debtor and the financial creditors. Thus, chances of opposition at admission stage are less, as it is usually a win-win situation. First, approval and reduction of burden on NCLT. Since the informational understanding has already been reached between financial creditors and corporate debtor, approval will be first, as practically there may not be opposition to resolution plan. There will be very little scope for litigation. And what I said, that the first formal, I mean, legal interference comes only at the stage of 54J. Otherwise, it is a little bit smooth flowing. At stage of admission, detailed examination of issues will not be required. Management continues with corporate data and hence no disturbance in running of enterprises. Friends, those who have handled the CIP process definitely appreciate of my saying these things. We know how much trouble, how much problem we face from the management of the corporate data while taking over the business operation of the CD as per the provision of the code. So here what's happened, management continues with the corporate data, hence there's no disturbance. In CIP, management of corporate data is handed over to the interim revolution professional. Practically, it is impossible for him to manage an enterprise of which he has no idea or exposure at all. Thus, effectively, management has to continue with the corporate data himself. In PPIP, the management continues with corporate data himself except in case of fraud. Thus, disturbance in routine management of enterprise is negligible. This is also another advantage PPIP has over CIRP. Base resolution plan is good starting point. The management of corporate data which has inside knowledge of business is in best position to determine way of recovery. Unless of course he is sick. The best resolution plan prepared by the corporate data having inside knowledge of business is a good starting point. In fact, if there is no impairment of operational creditors, committee of creditors can accept the best resolution plan itself with some improvements. So this is also, this best resolution plan is also an advantage. This makes the PPIP process in an advantageous position as compared to the CIRP position. Corporate data is allowed to be partnered with other persons. You know, when it is specifically clarified that the corporate data may submit the best resolution plan either individually or jointly with any other person. Explanation 1 to section 54A of Insolvency Code. It is mentioned there. Thus, he can rope in financial or technical or marketing partner as per requirement and submit best possible resolution plan. This is also an advantage. I think you will appreciate that. You know, the process allowed the CD, the promoter of the CD, he can find his partner. So it is, I mean, no doubt that the BRP will be a best possible plan for the CIRP process. Swiss challenge method to guess possible resolution plan. We have already discussed. The Swiss challenge method is a method where a bid is published and third parties are invited to match or better it. This system has been specifically provided in PPIP regulations. There is no such scope except as per regulation 39(1)A of CIP regulations, where it is mentioned that if it is mentioned during the invitation of resolution plan that this challenge method can be accepted, then COC may follow this challenge method. But here the Swiss challenge method is incorporated in the code itself. No special reference of this method to be made in the invitation while asking plan from the third party. So this is also an advantageous position of PPIP over CIRP. A Swiss challenge is a method of bidding in which an interested party initiates a proposal for a contract or the bid for a project. The details of the project are out in public and invites proposals from others interested in executing it. On receipt of these bids, that is from others, the original contractor gets an opportunity to match the best bid. Therefore, the method to discover the best price of the assets of the CD leads to maximization of value or gain, and it is only possible in PPI. So now we'll see the differences between CIRP and PPIRP after discussing all these things. First of all, the applicability. If you see the applicability, then CIRP, or it is applicable to all corporate debtors. Even MSME debtors are also covered under CIRP. But PPIRP, it is only meant for the MSME under Section 7 of Micro, Small and Medium Enterprises Development Act. It is not available for all the corporate debtors who are not covered under this section of MSMED Act 2006. PPIRP is not meant for them. Minimum default of amount for CIRP, it is 1 crore. I have already mentioned that due to the COVID pandemic period, COVID pandemic, the threshold limit, government bound to increase the threshold limit from 1 lakh to 1 crore with effect from 4/4/21. But here it is only 10 lakhs. So if the default is 10 lakhs, the CD can apply for the PPI. Who can initiate? Anybody, any FC, OC or CD. But here CD with the approval of 66% FC by voting share other than related party can only initiate the application. And therefore, friends, you will appreciate there is a vested interest of CD to get through this process. So there is very little chance that this PPIP process will fail. Preconditions to initiation of the process: date and default for CIRP. Date and default are the only preconditions. For OCs, demand notice and no pending disputes. But for PPIP, prerequisites other than default have been mentioned in section 54A. The eligibility section categorically mentioned who is eligible and how this application will be filed. Time period from commencement date 180 days, which may be extended to 330 days for CIRP. But here it is only 120 days. No extensions allowed. Also, the COC approved resolution plan to be submitted to adjudicating authority only within 90 days time. So definitely PPIRP has a very shorter period of time for completion of the process. Preparation of information memorandum for CIRP, RP to prepare the IM based on the books of accounts of the CD and claim received by the RP. But in PPIP, to be prepared by RP on the basis of preliminary information submitted by CD under section 54G. We have already seen that at the time of discussion, CD will prepare a PIM, preliminary information memorandum, and that will be submitted to RP within 2 days from the commencement date. And RP based on that thing. So chances of omissions, friends, I mean, all of us aware that how many litigations are there for the, in not complete information memorandum submitted to the resolution applicant, prospective resolution applicant. But that chance is very minimal in case of PPRP because the base document is already prepared by the corporate. Management of affairs of the CD during the process, as per in CIRP, this management vests with IRP and RP, but PPRP management to vest with CD unless otherwise directed by COC and approved by AA. Consequence of failure: initiation of liquidation process, in CIRP. There is no other way. If the resolution plan is not approved, or if there is no resolution plan within the stipulated time frame, the A will pass the liquidation order for the corporate debtor under CIRP. But in PPIRP, CIRP may be initiated by the COC at any time after I think after PPIRP, but before approval of resolution plan by a vote of 66% of voting share of the COC. So it is possible for the COC to initiate CIRP process, even though initially go for the PPIRP process. Consequence of management vesting with RP not applicable in case of PIP, because management is already vested in the hands of RP. But in case of PPIP, if no change in the management and control of the CD, then A, resolution plan of the CD shall be rejected by the NCLT, and B, automatic liquidation under section 54L4. So if the management is not vested in the hands of the RP or in the hands of the person whom the adjudicating authority mentioned in his order while passing the order under section 54J, the resolution plan will be rejected by the adjudicating authority, and there will be an automatic liquidation order under section 54A. So what are the advantages of PPIP? First of all, it is definitely a cost and time effective process. It focuses on preservation of value while safeguarding the interest of all stakeholders. Section 29A check is done at the preliminary stage, because at the eligibility stage it is done, thereby reducing the litigations by promoters of the CD at a later stage, making the process more efficient. The focus is ongoing, but on getting the best resolution plan, and hence third-party resolution plans are also possible. The claims of operational creditors have been given high importance, and a resolution plan that does not impair their rights is preferred. Minimum loss of reputation and court intervention. I mean, there is really absolutely negligible intervention of the court, barring in some cases. Moratorium will help ease the burden on the CD and thus ensure that the CD can work back to the track, on the track. Provides for strict penalties in case the misuse of provisions, which should act as a deterrent for the unscrupulous management promoters from resorting to the scheme, and only genuine matters may reach to the final stages. This required check and balances, friends, we have seen that already that has been incorporated in the PPIP processes, where the unscrupulous promoters or management with malified intention cannot get through with the approval of the PPIP process. It has to be terminated. It will get terminated. But PPIP also has some concern area. These are as follows: that procedural delays may defeat the entire purpose of the scheme. Because of such short time provided in the code for the completion of the PPIP, and there is no provision for the extension of time. So any procedural delay may defeat the entire process of the scheme, that is, may lead to the termination of the process. Strict timelines may mean that often no resolution is achieved within 90 days period as prescribed under section 54B. Further notation, which I have already said. Initiation of liquidation by the order of adjudicating authority in terms of section 54L4 will rob of the CD and its stakeholders a legitimate opportunity of revival that may have been provided through CIR. However, this will save considerable time and resources before initiating the liquidation when no resolution is envisaged. You know what's happening, that in case of CIRP, if the resolution plan fails or there is no resolution plan, the adjudicating authority ordered for the liquidation process. But even then, the city or the stakeholder had the opportunity to represent them with some, idea or with some offer to revive the corporate debtor. And there are many case laws where they are given the opportunity to present their case to be heard before the NCLAT or Supreme Court, etc. But in case of PPRP, since it is mentioned in the code itself, there is no such opportunity given to the city or its stakeholder to revive it for its revival once the liquidation order is passed by the adjudicating authority. It is bound to happen. So it is said that they will be robbed by this order. So this is also a concerned area for PPI, because there is no way the CD or its stakeholders can represent themselves for stopping that liquidation. So now this is the timeline for the completion of PPIP. I have prepared these things from the source IBBI website. So if you see the commencement of PPIP and appointment of RP as the initiation stage, that is time T, the commencement itself. Then submission of list of claims, preliminary information, memorandum and BIP, it has to be completed within 2 days, that is T+2. Similarly, the public announcement will also be to be required to be completed within 2 days from the commencement date, that is T+2. Then the appointment of the registered valuers to be done by the RP within 3 days from the appointment of RP, that is T+3. Then constitution of COC within 7 days from the commencement of PPIRP, that is T+7. Then it is mentioned the first meeting of the COC within 7 days from the constitution of COC, that is T+14. 7 days for the constitution and 7 days for the first meeting. Submission of information memorandum within 14 days from the commencement of PPRP. Again, the time frame is T+14. This information memorandum will be submitted before COC for their consideration by the RP. So it is again T+14. That is the first date for holding the COC meeting. Publication for invitation of resolution plan within 21 days from the date of commencement of PPI. So within 21 days of the commencement, the COC either approve the best resolution plan or advise the RP for the publication of invitation of the resolution plan from the outside, from the third party. Receipt of resolution plan at least 15 days from the publication of information for resolution plan. So it is T+36. 21 plus 15, 36 days. Evaluation and approval of resolution plan within 89 days from the commencement of PPRP, that is T+19. 89. Then RP to form opinion on evidence transactions. It is within 30 days of the commencement of PPIP. Then T plus 30. RP to make determination of evidence transaction within 45 days. T plus 45. RP to make application to AA within 60 days. T plus 60. Submission, because you know section 26 is applicable for PPI also. So all these things will done parallel. So a submission of COC approved resolution plan application for termination of PPRP within 90 days from the commencement of PPRP is T plus 90, and approval of the resolution plan and order for termination of PPRP is 120 days. T plus 120. So this is the timeline prescribed for the completion of the PPIP process. And along with, I have mentioned it is mentioned the sections also. So it will go accordingly. Okay. So friend, I am through with my presentation, but what I said, I told you earlier that I want to go back to that objective slide now. So what I already mentioned to you, that through objective, you can understand, you can analyze each and every action, every decision, transaction done under the code, as per the provisions of the code. So here also, if you see the, so if you see the objective of IBC, here the PPRP, the main objective of the code is firstly the maximization of value of assets, and then promote, sorry, it is wrongly mentioned here. I think it is in the earlier presentation. So to promote the entrepreneurship, PPIRP has been made as an alternate solution process for CIRP, mainly first the maximization value of assets, because you know the control is given to the debtors, so it is expected, and they are the responsible for running the company on a going concern basis. So it is expected that they will run the company for its best interest, and thereby the value of the assets will be maximized. And to promote the entrepreneurship, because as I said, during the COVID-19 pandemic time, the most affected area sector was the MSME, and the main purpose for bringing up the PPIRP process is to give the MSME enterprises, MSME sector an opportunity to control their own businesses, which lead to the promote of entrepreneurship for MSME. So with these things, friends, I am through with my presentation. If you have any question, you can ask me. Any question you have? We are in Q&A slides.
Participants, if you have any question, you may please ask directly from
Anything in the chat box? I have not seen. Just a minute. Can I stop my presentation?
Yes, sir.
Anything in the chat box? No voice. I'm audible. I mean, I got the message that no voice, no voice.
Sir, it was there when we had 10 minutes break.
Okay. So friend, before I say thanks to you, I want to inform you one thing. look, for some reason, the initiation of PPIP has not become very lucrative procedure. Maybe one of the reasons that it is only made available for the MSME business, or maybe for other reasons, but it is not a very lucrative one. Till now, I mean, till 31st March 2023, from its inception, that is 4th April 2021, only 6 cases, the application was filed for under a PPIRP process, out of which 1 application was subsequently withdrawn. And remaining 5 application, only there is a final order passed in respect only 1 corporator, that is Amrit Industries and Accurus Finance Corporation and Credit. They acquired the business of Amrit India as a by submitting their BAP, best alternate plan. As a third party, they have acquired the business of the Amrit Industries. So it is not a very encouraging scenario for the PPIP till date, but I think Government of India has realized the things, and they have decided to introduce amendment to the code in this ensuing monsoon session. I think that monsoon session of Parliament will start from the next week of this month. So they have planned to introduce some amendment in the IBC code, where they want to offer this PPIRP process to all, not only for the MSME, but to all corporate debtors. So let's see after this this amendment or introduction of these changes, how this PPIRP process works. So with this, I am through with my presentation. Again, I am asking if you have any question, you can ask. Any question?
Sir, I don't think participants have much queries.
Yeah,
I
tell
would
me.
like to present formal vote of thanks to you for sparing a valuable time for the session and for the participants. Thank you, sir, on behalf of ICSI IPA. You have spared this much of time and knowledge with the participants. Thank you so much.
Thank you so much. Thank you for it.
Thank you. Thanks.
But again, if you have any query, you can ask me. I mean, what I said that you will have my contact details, my email ID. Just put the reference of this session so that I can recognize you. Yes, okay. Okay. So can you conclude it, the session today?
Yeah, yes, sir.
So thank you so much.